Good afternoon, everyone. Thank you once again for joining us. Today, as always, I have the pleasure of speaking with Professor Stephen D. Schwinn at the UIC School of Law in Chicago, Illinois. Professor Schwinn, thank you again for joining us during this busy, busy time.
Kathy, it's a real pleasure. Good to be with you.
We are pleased to have you to unpack some interesting ongoings at the court last week and this upcoming week. So let's jump right into it. There's lots to discuss. The court's sort of been second fiddle, if you will, to some of the news media this week, but I think some of the arguments we've been hearing and we're going to hear are pretty important. So let's turn back the clock a little bit. What happened on Wednesday in the argument of Fulton versus Philadelphia? What did you think was interesting? Where do we see this case going?
Yeah, so the court heard oral argument on Wednesday in the Fulton case. And just a quick reminder, this was the case where Catholic Social Services, the city of Philadelphia had a provision in its contract for foster care services with Catholic Social Services that prohibited discrimination on the basis of sexual orientation. The city discovered that Catholic Social Services was not recommending placement of children in the foster care program to same-sex families. And so the city then dropped that portion of its contract with CSS. CSS then turned around and sued and argued that the city violated its free exercise rights under the religion clause in the First Amendment and also violated its free speech rights. The court heard oral argument on Wednesday, and I got to say, what I took away from oral argument is that the court as a whole was probably looking for a kind of narrow way to deal with this case, maybe even looking for a compromise position between the two parties. A number of justices floated potential compromises. CCS didn't really respond that well to potential compromises, but that's not to say that the court wouldn't come up with a compromise. I guess what I'm saying, Kathy, is that the real big issue in the case, whether the court would overturn Smith, I think is probably not going to turn out to be a big issue in the case. I did not read from the justices that there was a lot of enthusiasm to overturn Smith. What I read was, let's look for a narrower way to resolve this dispute.
Yeah, one of the things I think, building on that point you made about sort of the unwillingness or the desire to maybe not directly overturn Smith, I thought came out pretty directly from our newest justice, Justice Barrett. I was really struck by the line. She had a couple of lines about saying, if you can win this in other ways, why are you asking us to overturn precedent? Which I thought was really telling. She's obviously the newest justice on the court, and we're really trying to get a feel for how she's going to handle some of these cases. And I think there was some discussion coming with her coming to the court as to how she would deal with some of these, particularly LGBTQ issues, religion issues. And as we know, Fulton versus Philadelphia sits right at the intersections of those. So for me, that was really instructive and interesting coming out of this argument. And I think your point about looking for a narrow compromise, that's literally what the top of my notes say, that this was they're looking for narrowed. I thought it was really a nuanced argument. And you really saw the justices trying to tease out a way to find a way to come to an agreement on this case without doing something big or doing something really splashy in their decision.
Yeah, I totally agree, and I think you hit it on the nose with Justice Barrett. She asked not only do we have to overturn Smith, but if we were to, what do you suggest we replace it with? And I don't think the answer was really very satisfying to anybody. Of course, we don't know exactly what the response was with this kind of telephonic exchange, this our sort of weird COVID oral arguments. But still, I'm not sure that there is a reasonable alternative to Smith that would get a majority of justices on the court. As to your latter point, the way the arguments played out, Kathy, I thought was really interesting. They dug into the details of this case in a lot of different ways, right? So there were questions about whether CSS should be considered a contractor of the city and therefore give a little bit more leeway to the city in terms of the rules that it establishes with its contractors, or instead whether the city's non-discrimination policy was more like a kind of licensing arrangement or a general law that was applying to CCS. So I thought that was interesting. A lot of discussion about the city's exemptions and exceptions to the policy. And what the city was trying to do here is distinguish between exemptions and exceptions that applied at the actual placement level when the city places children with families versus exemptions and exceptions that apply at the recommendation level, the certification level, which is the level where CSS is involved. And that's really important because if the policy is rife with exceptions, then what CSS says is, look, it's not a generally applicable policy. It actually is designed to target our religious beliefs, and that raises a whole different set of problems and a different level of scrutiny for the city's policy. Is there anything else that you picked up in the oral arguments?
Yeah, I think you've said it perfectly, and it tickled in the back of my mind this idea that they spent a lot of time really digging into the facts of this case,
Yeah.
and really in a way that we don't often see the Supreme Court, right? So Supreme Court isn't supposed to be going into the facts of specific cases unless it's like a water law case that's there on original jurisdiction. This is a court that does not go to the original record most of the time. And I think you're totally right. The sort of how CSS is viewed by the court, is it a contract? Is this a license? Is really important. I also think what was really important was you had Justice Alito asking about what the actual impact of the city's policy is, which isn't something we often see the court asking, how does this play out in reality? We see death penalty cases where they don't necessarily get to you in that aspect. And he directly asked, have there been same-sex couples that have been denied foster care review because of by CSS? And the facts on the record show that there's not been, in part because no same-sex couples have applied to CSS. But to me, that was really interesting. And I think that speaks to your earlier point about this case really presented the court with a difficult question, and one that I think they're just trying to find a compromise on. And I think, as you mentioned, there's a lot of really important policy questions at issue here.
Yeah, I think there are, and I agree. I think that's exactly right, and it does underscore that I think the court's looking for some sort of narrow out here. The other thing that I picked up in the oral arguments was I was a little surprised at how much role Obergefell played in the actual oral arguments. And Justice Alito took some pot shots at Obergefell, tried to find some ways around it. Related to the Obergefell discussion, there was a lot of discussion about what this would mean if the non-discrimination clause prohibited discrimination not by sexual orientation, but instead by race. And there was a religious objection to that. What's the difference? And I got to say, that discussion was wholly unsatisfying in my view. I think unsatisfying for many of the justices as well. What CSS's position was, and the federal government's position too, is that racial discrimination is different in our society. We've got a history of racial discrimination that makes us especially attuned to anti-discrimination efforts and supportive of anti-discrimination efforts, and that just doesn't apply to anti-discrimination with regard to sexual orientation. I'm not sure that's really satisfying to all but maybe a couple on the court. We'll have to see how that plays.
Yeah, I think you're spot on. I think that the responses to that, it seemed like Justice Kagan in particular was really unsatisfied with how that question was answered, or that analogy was made.
Yeah, and you and I have talked before, Kathy, that it's not that long ago in our history where we did see religious objections to anti-discrimination laws by race, and so this is not a new thing. I mean, nobody's really kind of surprised by this, and I think the court may have to wrestle with the difference between anti-discrimination by race, anti-discrimination by sexual orientation, and if it decides that it wants to distinguish between those, come up with a meaningful way to distinguish between those. And I got to tell you, I'm just not sure that there is.
Yeah, no, I agree with you on that. I think that this case really shines a shadow on that tension that we've been talking about in this arena, and I think it's heightened even more so because it's about foster kids. It's about placing kids in loving homes by an organization that's done this for generations. And so this isn't some of the other challenges we've seen about a bakery or weddings. This is something different. And I think the court really felt that, and you could see the justices struggling with that.
Absolutely. And that just loops back to your awesome point about the court dealing so much with the facts of the case, right?
Mm.
How long has CSS been doing this? How many families have they served? How many children have they placed? I mean, this is a fantastic organization and has a great record. Everybody agrees with regard to placing foster care children. The question is, can they do it in a discriminatory way?
Right. Yeah. So sort of building on the discussion about policy issues and perhaps the court trying to do something narrowly or not narrowly, let's look forward a little bit, and the case that's getting argued towards the end of this coming week, Texas versus California, California versus Texas, the ACA case, whatever name we want to give it. Uh, can you talk to us a little bit about this ACA challenge that is once again before the court? It just does not seem to ever want to go away. And I know there's sort of three main issues. We've got standing, we've got the individual mandate, and the possibility of severability. So maybe we take those one at a time and sort of walk through what the justices may be dealing with and questioning the advocates about.
Yeah, sure. So in order to understand standing, I think we have to understand what the Congress did to the individual mandate or universal coverage provision in 2017. This is the provision in the Affordable Care Act that requires us each to have insurance. If we don't get it through our employer, through Medicare, Medicaid, if we don't buy it on the exchange, then we have to pay what Congress called a tax penalty. And we'll remember from the very first ACA challenge, NFIB versus Sebelius, that the Supreme Court said Congress had authority to enact the individual mandate or universal coverage provision as a tax because there was a positive tax penalty for not complying. In other words, what Chief Justice Roberts wrote in the opinion for the court on this point was that because it potentially raises revenue for the government, it's a valid tax. Now, Congress read that and said, well, we want to do away with the ACA. They couldn't do away with the whole ACA, but what they could do is zero out the tax penalty for the universal coverage provision. What this meant was the individual mandate or universal coverage provision stayed on the books, but the tax penalty for noncompliance was $0. Now, the opponents of the ACA reckoned that that meant that Congress then could no longer validly enact the individual mandate, right? Because if it doesn't raise revenue for the government, it's not a tax, and it's not raising revenue if the penalty is only $0. So individuals and states do, and this is where standing comes in. The question here is, if you're not penalized for not getting insurance, how are you harmed in order to get your ticket into federal court, right? So there are a couple of individuals, and the question is, look, there's no harm here because you're not penalized for not getting insurance. Now, what they say is, well, no, we're not penalized, but the mandate still stays on the books, and that's a kind of compulsion for us to comply, right? And so we feel like we need to comply. A bunch of states joined the suit as well, and what they're claiming, they've got kind of an interesting standing theory here. What they're claiming is that we states are affected by other provisions of the Affordable Care Act that's impacted by the individual mandate and the citizens in our state who do or don't comply with it. And those impacts are the harm to us, which is interesting because in some ways, that seems to get the cart before the horse, right? With regard to the severability question that we'll talk about in a second. In other words, what they're saying is there are other provisions that we're enforcing under the Affordable Care Act that are harming us, and therefore we have standing to challenge the individual mandate. I'm not sure the court's going to go for that. Standing, I think, is a really hard issue in this case and a really easy out for the court to not deal with the harder questions, the second and third question that you mentioned. So the individual mandate we already talked about. The question here is, does Congress have authority under its taxing power to enact an individual mandate with a tax penalty of $0? I think that's a hard question given the way Chief Justice Roberts wrote the opinion in the NFIB versus Sebelius case. Now, we can talk a little bit more about this, but Congress could simply replace that $0 penalty with any positive amount. And thereby undo any ruling against the individual mandate that the Supreme Court might issue. But still, I think that's a worry given the way Chief Justice Roberts' opinion reads in NFIB versus Sebelius. And then finally, the severability question. Remember in 2010 when Congress originally wrote the Affordable Care Act, it wrote it as this, highly integrated series of individual laws, individual requirements that were all really well integrated. So you had the individual mandate working hand in hand with a non-discrimination provision, the community rating provision, and then all these other provisions across the board that regulated the insurance market, provided subsidies, enhanced Medicaid, and even created the exchanges, and even did things like allowed youth to stay on their parents' health insurance until age 26. So what Congress originally said was that all these provisions are really integrally intertwined, which kind of sounds like they're not severable. But then fast forward to 2017, when Congress zeroed out the individual mandate, Congress did not take away those other provisions of the Affordable Care Act. And in fact, those other provisions of the Affordable Care Act continue to work. And so that suggests that the individual mandate may be severable. And so, the way the court looks at that, whether it looks at it through an original ACA lens or through an as amended in 2017 lens, I think is going to be really key to the severability question. But Kathy, I know that you had some thoughts on severability as well. What's your thinking about this?
Steve, I'm happy to turn to severability and share my thoughts. I did want to ask you one follow-up question on standing, though, before we turn to severability, because I think you're right that standing potentially gives the justices an out here if they don't want to go down all of these thorny paths. If the justices rule that say the individual plaintiffs have standing, but the states don't, what happens then?
Yeah, it's a really good question. So the case would go forward and the justices would hear the case, but they would hear it with an eye toward the plaintiffs who do have standing and what the relief that they could provide to the individuals, as opposed to the potentially different relief that they might provide to the states, or vice versa. If they determined that the states had standing, but the individuals did not, the case could similarly move forward, but that may affect the relief that they could give. It's kind of interesting. The federal government here, I think, is trying to really, thread the needle and come up with a theory that allows the court to rule pretty aggressively against the Affordable Care Act, but in a limited way, only as to the litigants in the case. And so if the court were to go with the federal government's theory, this idea of a kind of split standing decision could become really important and meaningful in the court's ultimate ruling.
Yeah, interesting. Thank you for that clarification. I think it's helpful to see sort of the different choose your own adventure paths we could go on with this case.
Yes, that's exactly what it is. That's right.
Yeah. And building on those choose your own adventures, so the severability clause, I think you did a wonderful job of explaining sort of how this case can be viewed as a giant statute that can't be broken into pieces, or perhaps there's a potential to break it into pieces since some of those pieces have maybe already fallen off. And I think for me, the severability is the standing, I think, is really complicated. But I think the severability portion of this is really nuanced, and building a little bit on what we talked about in the Fulton versus Philadelphia case, I think maybe severability is where we could see some of the justices trying to find a compromise and a workaround in some of this. And I was really struck looking back at a case that was decided in the spring, one of the cases that was one of the first tele-argument cases, which is this Barr versus American Association of Political Consultants, which was a challenge to an exception to a statute. And the original statute was a ban on robocalls to cell phones. And there was an exception that was put forward that allowed for debt collection calls to go forward when they were done on behalf of the federal government. And a group of political consultants challenged the entire statute. In theory, they were challenging just the exception, but they wanted to be able to do robocalls to any cell phone in anticipation of the election. And what the court ended up doing was severing out the exception and saying, we're going to let the rest of the statute stand. This ban is still going to exist. You should not get political robocalls to your phone. But this federal debt collection exception, we're going to knock down. And although it was a divided court on this, although Justice Sotomayor went with the more conservative justices, but there was a divided opinion. The justices were all aligned on the severability. It was a Justice Kavanaugh opinion, and the dissenting justices would have had a different outcome, but they also agreed that the exception could be severed from the rest of it. Now, I think this is different than the ACA. Obviously, this exception was not a part of the original statute. It was not sort of central to the core aspect of the statute. But I think this is a recent reflection of how the justices at times are going to defer to Congress and what Congress did in the big sense. And then when there are small challenges, if they can pull that small thing out, they're going to maybe pull that small thing out if it lets congressional intent stand. And I think that goes to your point as to which intent do we look to? Do we look to the original intent of when Congress passed the ACA and what the statute should look like, or should we look at it from 2017? And I think that's a really important policy question and legal question too. And I don't know what the justices will do in that, but I think this Barr v. AAPC case at least shows what they've done recently on some of these issues.
Yeah, I think that's a really good point. And it does raise the possibility that the court could say that some provisions of the Affordable Care Act are severable and others are not, right?
Mm-hmm.
So I think that could be a possibility here as well.
Yeah. Well, lots to be seen, lots to have been seen last week, lots to be seen this upcoming week. Steve, I hope you will make time. I know you are very busy, but we'd love to have you here, and we'd love to have you back to sort of reflect on what's happened with the ACA case, maybe what's happening with some of the election challenges, and what we're looking forward to after Thanksgiving as well.
It's been a real pleasure, Kathy. Thank you.
Thanks, Steve.
Bye.